102 though, so who was closer? I said 103.
That's what I was gonna say.
You said 101.
We have 300. Dr. Banyan, how are you? Good to see you.
But
We have 321 people without
bragging
power
rights.
since 11 o'clock this morning off West Terry.
Oh, really?
Yeah.
Bless you.
We're gonna try.
Thank you.
He's having issues on his side.
2 and 3 is what
David Teriaki. Good afternoon. Can you hear us?
For the whole thing, but I won, just know that. Over under, the Nigel over under.
What would I remember? Breakfast?
Over under on when you
Nigel
get here.
over under. I
Oh,
got it
the
on
pot calling
I
it
got it
pot.
on I know. I was like, this is so great when it's not me.
103.
David Teriaki. Good afternoon. Can you hear us?
She caught us. We're in competition.
My phone is off.
My phone is off.
Remember when Fred's would go off and he'd like be all startled and then he's like looking at it trying to figure out.
It's on Zoom. How are you, Margaret? Are you still in Seattle? Portland, okay. You happy to be back here? Beautiful, isn't it?
How long? You don't need protection from him.
Until about 7.
Could be in North Carolina, right? Where they're also
Good afternoon, David. We're trying to reach you. Can you hear us?
Bueller.
Is your mic on?
No.
Is your speaker on so you can hear us?
Oh, you have such a long.
See, he said everything.
How are you?
I have no clue. Let me see. My assistant's the one that signed me
Because
on
Mr.
Zoom.
Teriyaki is Communicado.
Yeah, that's what I'm gonna have to ask another. Sure, no worries. That's there. Where's the link? They wanted us to call a number that was on that link. Right there. All right, what should we do? So click here. So let me. John? Hi. I can see
I'm wondering
everybody,
with that power outage that they're
and
having.
my audio is showing that I have audio.
Right.
Yeah,
Call this meeting
I
to
am
order.
speaking right now.
Roll call.
Mayor Gibson.
Here.
Councilmember Bogas. Deputy Mayor Purdon. Councilmember Carr. Councilmember Corey. Councilmember Fullick. Councilmember Fitzpatrick.
Let me scan.
Right, thank you. Public comment. If any public comment.
And I can't hear
The
them.
one chance to speak at this meeting.
We're trying to stall.
All right.
Meeting if you need it.
Okay.
Zoom is not here.
Thank you, Mayor and Council. This workshop was set up after the strategic planning session. There were several follow-up items that were discussed, one of which being a land use workshop to discuss the future land use map. And we feel it's very relatable this time as well in the new introduction of Senate Bill
That is
180.
very,
And
very
kind of discussing
scary.
with council the next steps that are
You
available
even have
to
a
us,
sinister laugh.
as well as many other interests in land development code changes,
You always wanted to
comp
be
plan
the wizard
updates,
behind the curtain.
and also how that ties into the EAR that we most recently done,
I
and some
know.
additional state-required amendments that are forthcoming. So with that, we're working on connecting Special Legal Counsel David Theriak, who's been with the city from at least 2017. And then also with us, we have Dr. Margaret Banyan, who is currently a research professor at Portland State for the Center of Public Service. And she has been with us 2014 or 15, even prior to, in discussions, and also some additional focus groups and outreach programs we did even prior to our work with the comp plan. And with that, I'm going to turn it over to Dr. Banyan.
Thank you. So, good to see everyone. Yes, thank you. Good to see everyone, and also members of staff and members of the public. So, great to be here again. Our plan, I'll just give just a brief
Which
background.
phone number should I
Some of
call?
you may know, yes, about 2012, I have some files from the city of Bonita Springs where I helped facilitate some neighborhood discussions, and that's where I got started working with the city. In 2014, 2015, through Florida Gulf Coast University, where I was a faculty member, we did the first evaluation appraisal review and amendment cycle. And then we also did the second evaluation appraisal review that in 2013, and then did the next cycle of amendments following that. So the nice thing for me is that I've been with the city for, that's probably 10, 13 years working with the city. So having a good understanding of where you've been with the comprehensive plan and plans have been helpful, I think, from some of that institutional knowledge.
Enter your meeting ID followed by pound.
So I also want to say just a shout out to some of the Florida Gulf Coast University students that we've happy to have provided the city with great talent and great staff. So I feel like a lot of this work for me is full circle. So our goal here today, good afternoon, Mr. Theriak. Oh, we see you. So part of the pleasure for me today is that it is really, for me, a lot of this work is supportive of public agencies, and that's where my heart lies, primarily. So with that, our plan for today is we have a presentation. We hope it's a dialogue. So the presentation is just kind of more or less talking points that we've divided up between Mr. Theriak, myself, Mr. Rooney, some planning staff to also jump in. And so that's kind of the flow that I'm hoping we can go through today.
Hello, hello.
We'll end the presentation with kind of a next steps discussion. So to the extent you want to kind of share that dialogue, then great. I think that's my introduction. So we can start with the overview of the presentation. But I need the presentation.
You could startle David to say, and in conclusion.
They're working on it. So we can, if you'd like, kind of go over some of the agenda topics in a little bit more detail. These are a bit out of order from the formal agenda that you have. Just in working through some of the presentation, it kind of made more logical sense to rearrange some of the topics. A little bit, Mr. Theriak will go through a little bit of the community planning history and what's been happening with comprehensive plans in the state of Florida. in the past. And also talk about Senate Bill 180, which is enough of a sea change that we'll be able to spend some time talking about the implications. And then I'll talk a little bit more about the City of Bonita Springs comprehensive planning history, some of the big strategies and frameworks that you've been looking at. We'll talk more about decision-making and look at the future land use map, and then move into next steps in discussion. So that is where we're at. I need Mr. Theriak for the next slide.
Can he even hear us?
I don't know.
Can you hear me? Can you hear me?
Any questions about our approach or what you'd like to cover today? Or thoughts?
Well, how about, are there any goals that any of the council members have that they hope to learn out of today's discussion that we could highlight as we go through?
I think especially Senate Bill 180 and how that impacts everything going forward. That does seem to be much more restrictive in terms of its language as it impacts the cities.
Yep.
You know, what have they cut back on our ability to do expansion?
Yep.
Buzz, the city manager, more significant.
Stemming back from some of your strategic plan workshop discussion, this was on your list of workshops that you wanted to hold. So was there anything from that that you, after reflecting on that session, that you're particularly interested in?
I think timing-wise, it's just, you're going to go ahead and address it, and that's essentially the build-out scope of both lands within the city of Bonita Springs, as well as particularly east of 75, what the build-out looks like of both county and city lands together.
Yep.
I don't know if we're going in turn or not, but, you know, it's the magic acronym at a certain point. How we see the DRGR in the future and what happens there is, we've got to address it. So it's part of our future. That's one of the things that I'd like to see us have more discussion on and more input from folks.
Well, I can get a little bit started. So, you know, obviously the history in Florida of post-World War II development was substantial. And beginning probably 1972, with some of the creation of the water control districts and other areas, there was early attempts by the legislature to start planning for future growth within the state. That eventually culminated in the early 1980s with the Growth Management Act, which created a entire division of the state, previously the Department of Community Affairs. We can hear you now, David.
Okay. Thank you.
We just got to the Growth Management Act.
I didn't understand it there.
That's not going to work.
Okay, so with the Growth Management Act, the state adopted a statewide comprehensive plan for planning, and I'm sure I'll get some elements of this inaccurate that Dr. Bannier or David can correct me, and required implementation at the local city and county level of growth comprehensive plans. And so in your comprehensive plan, you are laying out the plan for future growth, not only in different land uses, but that eventually ties into infrastructure and other elements and preservation, all of the elements you've all become accustomed to dealing with on a daily basis when we're reviewing these items. And that ties into broader regional efforts that were coordinated with the regional planning agencies, which existed and still exist at some level in the state, and then all ties into the state of Florida. And so when you would go through amendments, or you would adopt your plan, those plans would be reviewed by the state, and then they would comment and see how those implemented or worked with the goals and objectives laid out by the state, and also the goals and objectives that you laid out for yourself. And that would be the EAR process, the evaluation and appraisal report. So every 7 years, you go through, do an analysis of your comprehensive plan, say what has worked, what hasn't worked, where are you going with that, and implement changes to move that along. Then back in around 2009, the state legislature started to make drastic changes, culminating, I think it was Senate Bill 360 back in 2012, culminating in major revisions to the way the process worked. No longer was the Department of Community Affairs heavily involved. That department changed names, became part of the Department of Economic Opportunity. They would no longer get heavily invested in your local planning issues. You would only submit, your comp plan amendments to the state, but they would only look for major impacts with state resources. So you wouldn't get the same level of comments that you would get before. You'd almost get, in the prior regime, you'd get almost professional level comments detailing very, very detailed analysis of issues such as, what's your approach to existing subdivisions that are platted lots that don't seem to be building out? What's your growth for future? How does that tie into your infrastructure availability? Comments on wetlands and other items. All that kind of disappeared. And the obligations of the growth management still were there, but they were placed more firmly on the local government themselves to plan to handle these issues for themselves. So how that all translates is you develop your comprehensive plan, you lay out your vision for the future, then within 1 year of adopting a plan, you implement land development regulations to the nuts and bolts of that process. And so what you deal with on a regular basis, and what your planning members deal with, is they deal with the comprehensive plan changes, the big pictures, the 10,000-foot view. Then when that gets implemented through the land development regulations, and these come back as rezonings, special exceptions, plats, you are looking at those for their compliance, not only with those land development regulations, but with your adopted comprehensive plan. So that was the shorthand. I hope I covered that for David.
Yeah, and I think some of the things, so what we just had a little aside is we'll kind of skip over some of the state level work and kind of dig a little bit into the city.
And our hope then is then the most important part of this is that David's able to join us for the discussion regarding the Senate bill. So if we can, we're going to move into the.
I do want to add just a little bit to that kind of discussion about the state level. So where you saw with the initial Growth Management Act, a lot of state regulation on planning that waned, and then back again where the state is taking back over some control of decisions from local governments. So you see kind of an ebb and flow about how upfront and how much control local governments have had over time. And so we still have, I think with the initial Growth Management Act, their comprehensive plans are still required. And there's still elements of comprehensive plans that are required. Those have not gone away. But in terms of kind of how much the state has controlled or not controlled some of the local actions has changed. So when you look at your comprehensive plan, and I think we can kind of turn to that more or less now. Matt, if you've got control, that would be, so I don't know what slide, but That's the highlights of the 25-year history. Yep. There we go. Yep. So you can see this reflected a little bit in the city's, these are city-initiated plans and changes to the comprehensive plan. What I will note here is that much of the EAR process is designed to do two things. One, to respond to changes in state legislation. Some of you have been around enough to know this piece already. But the other piece is an opportunity for the city to look at its comprehensive plan and see where it's at. So that's what the purpose of the EAR is. So you see some of this EAR process reflected in some of the changes that the city has made. So just briefly, with this 25-year history, city was reincorporated around 1999, and around 2002 was your first comprehensive plan. That was a comprehensive plan that was based on a significant amount of public input, and it took, you can see, kind of 3 years to get that comp plan to adoption. So that also did include the DRGR provisions at that early planning stage. Around the early 2000s or so, the city took on some issues around started thinking about what that meant to have a downtown, and then putting into place some of the community redevelopment agency kind of efforts in an effort to look at investment in the downtown. With the downtown district and Old Town was all incorporated pretty early on. 2009 was where you saw, so that was the first EAR, as a result of the first EAR that was done. 2009 was adoption of the LDC code regulations for Old 41 and the redevelopment overlay. So there was, again, some kind of thinking about what does growth look like in the city of Bonita Springs. 2014 was kind of an important year as well for, and that was when the state was making a lot of changes. So a lot of changes were made at the state level in 2011. So around 2014, the city was responding to those changes because where you used to have concurrency for transportation, parks, schools, those concurrency requirements went away at the state level. So the city, for transportation, parks, and schools, could no longer deny permits based on capacity in those three areas. So you see sort of state movement and then city responding. 2019 was about the time where the city started really thinking about what it meant to start to alleviate some traffic on your major roads and start thinking pretty seriously about your transportation patterns. So Bonita Beach Road, there was a study, the Bonita Beach Road study. Out of that came a quadrant plan and some thinking about that corridor. So where you see the nodes and the quadrant plans, that was around 2019 after some of that thinking was reflected. That ended up in the comprehensive plan amendments.
I just wanted to add to that, one of the most important relevance of that is that once it's in the comprehensive plan, the state agencies have to recognize that community planning. So when they look at their own capital improvement projects, they have to recognize what the city adopted, what it wants for its own community. And that was important to create those overlays that we did.
Then 2020 was an interesting year for your comprehensive planning. This followed the 2016-2017 EAR. We recognized in that EAR process that there was state requirements for a coastal high hazard area. You also started moving on some of your downtown form-based code. So from a comprehensive plan standpoint, some of those things needed to be kind of caught up in in the comprehensive plan. Coastal high hazard area maps were a state requirement, and you had a coastal management area that was not the same as as the state required coastal high hazard. So we did a significant amount of work and thinking about what that meant and what that meant for the city. So in your current comprehensive plan, you have both a coastal management area with certain provisions about redevelopment and build back. And you also have that reflected in the coastal high hazard area relative to storms. So that was a big enough change that was an off-cycle change. And then you also had the downtown, at the same time, we did the downtown district, amended the comprehensive plan for the downtown district. What you don't see on here is the 2023 evaluation and appraisal. But at that time, we were at a point, I think, with the city where we could look at the comprehensive plan for a lot of fixes that hadn't been implemented. So we did a bit of a deeper dive, fixing many little things, name changes. We removed some of the implementation dates that were no longer relevant. So we did a lot of cleanup work in 2023, 2024, and that was recognized in 2024. That was sent up to the state. And where we're at now with comprehensive planning is that the state is asking that the city update its comprehensive plan to some legislation that reflects a 10 and 20-year planning horizon with demographics, and associated data and analysis. We also have to make sure all of the elements are reflecting that 10 and 20-year planning horizon. So that work will be coming up to be consistent with statute. I'm going to hold off there for a second and see if there's discussion, any additions of things that we missed. Oh, I need the microphone closer to me, apparently. Anything that we missed, anything that was important that you want to talk about, questions that you have about where we're at now?
Can you give a brief summary on the coastal maps and what that was and the differentiation between the two classifications that you referenced?
Yeah. So your coastal management area, I believe, was part of the first comprehensive plan. Is that right? And so that coastal management area reflected that there would be impacts from storms in the coastal areas, for lack of a better term. And so that was kind of drawn up to the downtown area, up to Old 41. And then the coastal management, the coastal high hazard area is a state term, and that state term requires that comprehensive plans reflect I think they were calling it at the time, the Zone 1 hurricane impact areas. So it was really the data analysis around flooding.
Turn your microphone on.
The surge zone.
There's a slosh map is what it's called. It's essentially the flooding impacts, and that is what, when those maps are adopted, that's what your coastal high hazard areas are. It doesn't reflect wind anymore. It previously reflected wind, I believe, as well.
And the definitions had changed in what was in our original comprehensive plan, and we were required to reflect that state model. So there was a lot of public feedback at that time that they were concerned that we were losing the aspects of the management of that coastal high hazard area if we were to remove it from the geographic location. So it was a large section of the city, but the slosh map or the state mandated map was a much smaller geographical area. So we wanted to find a tool to be able to provide goals, objectives, and policies for the original area, because that was the public feedback we received during that time.
And something we discussed when we were preparing for this meeting, kind of a heuristic for thinking about what the plan currently calls for. In the coastal areas in the west, we're trying to limit density, move people away from that area. In the east, you're essentially trying to preserve what's out there, and in the core, you're trying to
Let me check
encourage
if they-
all your redevelopment efforts
I
in
don't
that
wanna interrupt.
sense.
I'm
And so if you
speaking
think
right
about
now.
all the plan decisions you made,
Can they?
those are the three primary goals: limit development on the coast, limit development in the DRGR, and focus, infill development to higher densities in the core, and develop redevelopment strategies like your form-based code or the overlays to encourage those areas to develop out fuller.
So what were some of the examples that we modified as a result of these identified areas, like in downtown, where you've got the impacts of storm surge and that type of stuff, and the flooding that occurs along the Imperial
No,
River?
it's not muted. I've already
Well, there's
unmuted it.
practical elements that Matt can do, and then there's also the stuff that John's team can probably give you more detailed explanation.
And one of the things I'll just add from the comprehensive planning level, certain things at this state applied to the coastal high hazard area, such as sort of how you measure, some of the, I think there was some build back provisions also. So part of the strategy in that element was to really study what was important for the coastal high hazard area to focus on, and then in terms of the coastal management area, how did the city itself want to consider public investment into infrastructure. So that's one of the major provisions in the coastal management area, is not investing in infrastructure in that coastal management area.
So it's really a tie-in between the areas that are directly impacted by storm, but it's also the areas that have been identified for the collection of stormwater and avoiding stuff going back in impacting areas.
So I think what the state was trying to accomplish is many communities had the coastal high hazard area, and it had not been really looked at as, for example, ours went all the way further inland, which created some additional restrictions as well under the state mandate. And what we looked at is a balance of those, because the public was concerned that we were losing something within following the state's definition, but the city didn't have any option legally not to follow the state's definition. So we created the coastal management, so we could take elements of those and provide those protections within there, but also at the same time encouraging growth in the downtown, because it did go all the way to 041 Road originally. But that necessarily doesn't meet the modeling of the state as far as coastal high hazard definition. So even though we do experience flooding in some of those areas that are in the coastal management area, and we've put provisions in land development code and such, it doesn't meet the state's definition of a coastal high hazard.
I'm pulling the statute, because I think the definitions in the statute would be helpful, but essentially the coastal management element of your coastal elements is to limit public expenditures that subsidize development in coastal high hazard areas, protect human life from natural disasters, at the local government option, adopt adaptation areas, designated low-lying coastal zones that are experiencing coastal flooding, and if you go into the definition of what that means, that definition of adaptation areas is to consider adopting comprehensive plans which identify areas that experience coastal flooding due to high tides and storm surge and that are vulnerable to related impacts of rising sea levels for the purpose of prioritizing funding for infrastructure needs and adaptation planning. And you've seen, as a corollary to that, we've seen the resilience grants and other things from the state saying, okay, look, if you identify these areas and these are your mitigation plans, there's state money to help you look at those issues.
But haven't we recreated new DRGRs with our purchase of these homes on Dean Street? And we're not going to, aren't we redefining where the real flooding is and where we need to stop building?
So that would be a little bit separate of the state requirement of the coastal high hazard.
I know, I was trying to get in like 20 minutes ago.
Oh, sorry. But what I would suggest is, so there are through studies that the city has initiated that we know are repetitive loss areas. Additionally, even through our CRA program, we know where a concentration of those happened. the state and federal government made available, since we were, had received storms, that we could apply for programming, that if we could identify properties that are repetitive loss, that there isn't solutions that are found for that flooding, then we are able to purchase those properties, remove the structure, and they forever to remain not built on, so that no one's in harm's way in those locations.
Yeah,
DRGR that's needed.
There's no redefinition. Those homes that have been purchased, some of them are in the floodway, which is what was the Girl Scout camp in Texas. That was in the floodway. The floodway is an extremely regulated portion of a riverine flood zone, not storm surge, which I believe is what Derek and Dr. Banyan are speaking of. So we're not redoing anything. We're taking people out of harm's way where the homes were built 40 years ago in an area that people didn't understand was the most dangerous portion of a riverine flood zone. Not all of them. Some of them have been in the flood, just the typical flood area, but some of them are in the floodway. So there is no redefinition going on with those properties that have been purchased.
So I'd say that, where the corollary, how that affects what we're talking about today is when the state looked at, from a comprehensive plan, when they looked at the 35 coastal counties, they were thinking about your traditional, people want to live near the beach, people are building by the beach, that's where the focus on. They didn't address in the Growth Management Act does not address river flooding, other than in conservation efforts. I don't think it's that the state doesn't care about those issues. It's just not, it has not been the priority, because that's not where the growth has been. And of course, river flooding is something that Florida's dealt with for a long time. The actions that the city's been taking with respect to, that's been more driven by disasters, our local experience, and federal flood policy, and trying to deal with those issues. So we've been dealing with it at a practical level instead of at a major planning level.
You commented earlier, and just for clarification, I think you said that we're not necessarily at odds with the state as far as boundaries and definitions, but there's a difference between how we see it and how they see it. Does that present a problem or something that we need to solve going forward?
I'll let Dr. Banyan, but I believe the solution we came up with was we have the right as a community to establish a management area, coastal management area, which is not the definition of a coastal high hazard. Previously, that is the definition the state regulated us under, and it captured a much larger area, and the lands, the geographical lands incorporated in that definition, we were not in compliance with state law. So by creating a coastal management area for the city that we're able to put goals, objectives, and policies that the community wanted to see, balancing all those issues, we created that geographical area, and that was approved by the state. So we're following the state law and keeping the two separate definitions and two separate geographical areas moving forward.
So it doesn't really present a problem, or shouldn't present a problem going forward?
It should not. But
well,
yes,
we can use this to jump on into Senate Bill 180 real quick, if that helps.
well, yes.
Not that I wanted you to segue there, but.
So,
well, there's nothing you can do about it maybe right now, maybe a time that you're restricted from doing much about it.
So the coastal management area came first. The city defined the coastal management area first, 2002. So had an idea about limiting growth. When the coastal high hazard area requirements came on board, we kept both. The city kept both to say there's certain provisions that have to be considered in the coastal management area, and there's certain other considerations in the coastal high hazard area. And so the coastal high hazard area, of course, being the state definition. So we made the comp plan compliant, both with state statute and with the desires of the city. So fortunately, we didn't have to get rid of either one, and I think it gives some different levels of protection depending on which area you're talking about, because those don't overlap perfectly. just like Arlene was saying.
Just be clear, for all intents and purposes, we're compliant
Right.
right now.
Yeah, it's just something I think if you do more on your downtown area, these are things that have to be considered
And
as
that
you
was
start
an
to think
important
about.
factor we looked at, because in the coastal high hazard, you're limiting public infrastructure investment, you're limiting growth, you're limiting density, which is that was not presented as the goals of the community for the downtown. We wanted to see growth in the downtown. That is where it's selected for the form-based code for higher intensities on businesses. So that was the goal of the city. So we wanted to make sure we had the protections of the coastal management, but not hinder growth in where the community was asking for growth to occur.
Let me find it, John.
Yeah.
Because I had closed that.
So can I sort of try to get a framing of what we're talking about a little bit? So to me, the comprehensive plan is the blueprint for how we want the
Test.
city to evolve. The land use
Test.
regulations are the tools that we're
No,
going to
but-
use to accomplish the comprehensive plan. So it seems to
Yeah,
me
let's do
that
that.
somehow that we need to evaluate or grade our comprehensive plan. Is it accomplishing what it
Test.
want it to do? You know, is it promoting economic growth? Is it providing affordable housing? Those kinds of things.
Yes.
And then, is the land use tools that we have
Test.
the right tools
No, I can hear.
that we need to accomplish the comprehensive plan? Now, one of the things that gives me pause is the rate of growth of the population of Florida. I mean, annually, we're getting about 400,000 people moving into Florida from out of the
On my
state.
iPad, yeah.
A lot of them are coming down to Southwest Florida. So when we last looked at our comprehensive plan, did we anticipate the growth that's taking place? And did we anticipate what
Test.
we now see as the mandate for things like economic growth, affordable housing, and so forth, whether it's on a local basis or whether it's being sort of pushed by the legislature and
All right.
a very Republican government? And do we agree with that? So, yeah, how do we go about grading our comprehensive plan, and how do we go about evaluating the tools? Because it goes beyond resiliency and coastal high hazard and so forth and so on. I mean, is this where we're at? Are we grading our comprehensive plan, or are we just looking at the toolbox?
I think that this is.
Good afternoon. Test.
Oh, we're good. It's a great conversation for today, because I think one of the things that we really did want to get on the table was, what do
So-
you want to see happen? So sort of starting right now with a framework.
Yep,
about
I can
what
see
you want
Margaret
doing.
speaking. Can they see me?
We can see you.
We can see and hear you.
Yay.
Yay!
All right.
Success.
Bye. Thank you, John.
So if I clarify one thing, you are required under state law, which we just did in 2023,
Yes.
every 7 years to do exactly what you're saying. Does this comprehensive plan reflect the goals of the community? Is our blueprint working?
Right.
On top of that, in between that and during that process, you're receiving new legislation from the state
Right.
that requires different changes that might be in conflict with what the community would like to see. That does happen. And then we are required to make those amendments. Typically, they have been during the cycle, but as you'll see from the letter that Margaret is going to go through, the last time, they want one in between. They want changes in between. So having strategic planning sessions, reviewing the comp plan in a setting like this, all lead and are additional tools in saying when we are ready for our next updates to the amendments, we're kind of ripe for that since we have a direct mandate from the state to do so. Is there other things we want to think about? But at the same time, Special Counsel Theriak will let us know we have to be very cautious of all those things because of the new Senate bill.
And I think I do want to reiterate, so during that EAR cycle, so some of the materials that you see in the EAR report, the vacant lands map, where are the vacant lands, helps give you a way to do that evaluation, helps give council a way to perform that evaluation. That is something that in the next upcoming comprehensive plan changes we would be doing again, is to re-look at that vacant lands map and provide you with some other information and material so that you can determine, in part from a density and intensity standpoint, what is it accomplishing from that perspective? So that would help with that, I think. We can keep on talking a little bit more about the cities, kind of where you've been, or we can turn over to Mr. Theriak. What's your...
Mr. Theriak, we've been waiting.
I've been here, I've been waiting too.
Let's strike while the iron's hot.
Yes.
And so where we switched to, you maybe heard, is just talking about kind of the 25-year history of comprehensive planning for city-initiated plans. And we know that everyone is highly anticipating your previous slides, thinking about comprehensive plans in Florida, and then the implications of Senate Bill 180. So,
Did you hit anything about comprehensive planning in Florida? I wasn't able to hear for some of this.
yeah,
I
Derek
apologize.
talked a little bit about it.
I went over, David, just a general history of the Growth Management Act and then the changes in the late 2000s that stripped DCA of its heavy involvement. And that was about as far as we went.
Okay. Well, I'll spend a few minutes, and if I repeat anything that Derek said, just nudge me and I'll move on. I don't have, most of my presentation today is going to be on Senate Bill 180 and then legislative, quasi-judicial, and compatibility. But comprehensive plans are required basically through 3 different Florida statutes beginning in 1975. What you're probably familiar with is Chapter 163 Florida statutes, which sets out the requirements for a local government to adopt a comprehensive plan, what needs to be included in that comprehensive plan. Prior to 1975, there was very little comprehensive planning taking place, and the state started undergoing a tremendous growth rate, and there were a lot of concerns about the unintended consequences associated with that growth that was occurring environmentally and infrastructure. So the first attempt was a Growth Management Act that was adopted in 75, and then it was revisited substantially in 1985. And it changed the format by giving the Department of Community Affairs as a state agency oversight over comprehensive planning throughout all local governments in the state of Florida. And DCA had the ability to challenge comprehensive plans if they did not meet the requirements of Chapter 163. They also had the ability to challenge comp plan amendments. And under limited circumstances, they would have the ability to raise an issue with land development codes if the land development codes were not properly implementing the comprehensive plan. It was really a state-driven approach. Some complained that it was too heavy-handed. It was probably the pinnacle of the growth management process, with the Department of Community Affairs being the lead. Ever since, I would say, the 90s, growth management has been chipped away. Getting away from a state central agency regulating all the local governments, every action, to trying to focus in more on certain state interests that aren't identified in the statute, but the legislature has limited what's now called, it was the Department of Community Affairs, then it became the Department of Economic Opportunity, and now it's called the Department of Commerce. And the pendulum has swung back to much more leniency by the state and much more control by the local government. When the 1995 Act was adopted, the criticism was that local governments were quite simply not controlling growth and were not ensuring that infrastructure and facilities would be available concurrent with that growth. And the the state was supposed to ensure that that would occur through the comp planning, but the crux of the 1985 Act was a section called 163.3215, and that gave citizen enforcement of decisions by a local government, whether it be a county or it be a city. And if a citizen believed that the local government had approved a development order that was inconsistent with the comprehensive plan, the citizen would have the ability to sue the local government to basically hold the local government's feet to the fire. And that citizen enforcement was really crucial, at least to the statutory framework that was set up in 1985. Since then, the scope of citizen enforcement has been narrowed. There are some cases that the legislature recently incorporated into 163 that restricts what issues can be raised by a local citizen challenging a development order's consistency with the comp plan. And probably the most damning as it pertained to citizen enforcement is there is now a prevailing party provision. So if a citizen challenges a local government, that the local government's approval of a development order is inconsistent with a comprehensive plan, and the citizen loses, the citizen's on the hook for attorney's fees. And that has had an extremely chilling effect on citizen enforcement of comp plan issues at the local government level. So coupled with the state pulling back, coupled with the citizen attorney's fee provision, the pendulum is swung substantially away from what the intent was in 1985. So now local governments have more flexibility than they did in 85. There still is that enforcement provision, but there are very few. I'll tell you, when the statute passed, there were multiple lawsuits across the state that dismissed their challenges because of the attorney's fee provision. And it really has had that chilling effect on being able to enforce the 163.3215 consistency requirement. The relationship between comp plans and land development codes. In Florida, there's a case called Machado, which states that a comprehensive plan is like a local government's constitution. And the land development code is supposed to implement the comprehensive plan. A land development code can be more restrictive than a comprehensive plan. Let's say you have a comprehensive plan residential category that allows for up to 4 dwelling units per acre. A local government can implement that category by a zoning district that allows less than 4. The local government has the discretion in its LDRs to be more restrictive. What a local government can't do is use its LDRs to grant more entitlements than what are authorized in the comprehensive plan. And there is a statutory process, as I said earlier, for a citizen to write a letter to the Department of Community Affairs, now Department of Commerce, to complain about the LDRs not being properly implemented or properly adopted. It's not used frequently, but it does exist. You also cannot grant a variance to a comprehensive plan provision, whereas you can grant variance to land development code requirements. And that would lead me into Senate Bill 180. I don't know if we have the slide up that shows the text of Section 28, number 1. Can you all see that?
The slide is up.
Okay, great. In July, Governor DeSantis signed Senate Bill 180. It's a lengthy bill, and one section particularly pertains to cities and counties throughout Florida. And this is the actual text from section 28, sub 1. And let's turn to the next slide, Margaret. Please. As a result of section 1, these bullets are summarize what Bonita Springs can do or cannot do. The first one, Bonita Springs may not propose or adopt any moratorium on construction, reconstruction, or redevelopment of any property damaged by the hurricanes listed in section 28. Bonita Springs may not propose or adopt more restrictive or burdensome amendments to its comprehensive plan or land development regulations before October 1, 2027. Bonita Springs may not propose or adopt more restrictive or burdensome procedures concerning review, approval, or issuance of a site plan, development permit, or development order before October 1, 2027. Any such moratorium or restrictive or burdensome comprehensive plan amendment, land development regulation, or procedure shall be null and void ab initio. And then to me, one of the most troubling parts of section 28 is this subsection applies retroactively to August 1, 2024. So this is not a statute that simply says going forward, Bonita Springs, you can't do a moratorium regarding construction. You can't adopt more restrictive or burdensome amendments to the comp plan, and you can't adopt more burdensome or restrictive procedures regarding the review, approval, or issuance of a development order. But it's reaching back to August 1st, 2024. Next slide, please. Now, there is an exception for an application that's initiated by a private party. That's not subject to section 28. And then there is an enforcement provision laid out in section 28, which, and I've summarized them in these bullets. A resident or the owner of a business in Bonita Springs may bring a civil action for declaratory and injunctive relief against the city for a violation of this section. So if there is something that took place retroactively to August of 2024 that a resident or a business owner believes is more restrictive and violates section 28, they are authorized to bring a lawsuit against the city for violating section 28. The resident or business owner is entitled to a preliminary injunction against the city, preventing implementation of the moratorium or the comp plan amendment, land development reg or procedure. If the civil suit is successful, the resident or business owner is entitled to reasonable attorney's fees and costs. And there is a safe harbor provision regarding attorney's fees. If the resident writes a letter to the city, putting the city on notice that they believe the city has violated section 28, the city repeals or posts a notice that they're going to repeal the comp plan amendment and the land development reg or the procedure within 14 days of receipt of the written notice, then attorney's fees are not available to that property owner. So essentially, from a local government perspective, I think there's only one city that's not captured by section 28 that's up in the Panhandle. Basically, the entire state is captured by section 28. And it's freezing your ability as a local government to adopt any new regulations that might be more restrictive or that might impose a more difficult process to follow. It's more restrictive or more burdensome. So most local governments right now are looking at, are there any actions that they took prior to July 2025 back to August 2024 that is captured by section 28. I know, for example, in Walton County, they've already, even without getting a written notice, they've already issued a notice that they're going to repeal several ordinances that they adopted because of their concern that they're going to be subject to an award of attorney's fees if they don't repeal. There is talk that the Florida legislature may address some type of glitch bill because of the scope of what's being caught by Section 28, and I believe it's an early session this year. There's also some talk of potential litigation on behalf of some of the local governments in Florida. I think from a litigation perspective, the part that's probably the most troubling is the retroactivity concept. The legislature has the ability to restrict a local government's home rule power moving forward. The retroactive part, I think, is troublesome. Any questions on Section 28?
David, this is Derek. I'm going to chime in one bit here. So this has caused a lot of concern around the state, but what I would remind is in 2023, there was Senate Bill 250, which placed essentially the same restrictions across an area of 100 miles from the landfall of hurricanes Ian and Nicole. So the city is, and that also had retroactive provisions in it going back to 2022. So for purposes of the city, we've been already operating under the restrictions imposed by the current Senate Bill 180 for a couple of years. And as you recall, when we've had conversations about making changes to some of our processes, the Board of Zoning, the Zoning Board, others, those restrictions have been put on hold because if to the extent they're deemed to be more restrictive, they would be violator of that law. Now, one of the sets of revisions and code changes we've made since then that may be affected of it, Councilman Corey brought up at the last meeting, which these are the look-back provisions that we adopted with respect to our updates for post-disaster review. So there's another section within Senate Bill 180 that prohibits that action. And so you've asked for a resolution on that. We'll be bringing a resolution notice on the meeting on the 20th, identifying that as an issue that we are not enforcing. Well, that continues to get worked out, and that's likely to be one of the issues addressed by the glitch bill. So for purposes of today's discussion, the primary concern with respect to Senate Bill 180 is how it affects you moving forward. I don't think there's any dispute that if there is a private applicant moves forward with a change, that's not subject to the restriction except to the extent it may impact others. With respect to changes that you may want to do that are less restrictive, there's no restriction either. So if there was a sudden desire to increase densities throughout the city, I doubt that would be viewed as a restriction under this statute. So I just want to make sure that you understand what the issue is. I'm not as concerned about the look-back issues as other parts of the state which are now being affected by that, although there were some even within 100 miles of Ian and Nicole who didn't realize it and continued to make more restrictive adoptions. For our purposes, the issue is until October 2027, we can't adopt anything new. Now, for planning purposes, for working on long-term planning and then implementing regulations, the city can still work on all of those efforts, outreach, everything, up and just make the effective date October 2027. So it's not that we can't implement anything. We can go ahead and start working on anything that the council desires to work on.
So to clarify real quick, this applies to ordinances under the Land Development Code and the Comprehensive Plan, but does not apply to any zoning requests or variances that would be in a quasi-judicial situation?
Not individually, because we're not enforcing something. Someone is operating under the existing regulations asking for something.
I did want to clarify one other thing. We have been made aware by the state that the state floodplain coordinator is in direct correspondence with FEMA to determine the implementation of Senate Bill 180 on CRS and other NFIP requirements under federal law. So there should be an opinion coming from FEMA to the state, which the state will disseminate, because right now the language is in direct conflict.
If I can ask David a question. David, this is asking you for an opinion, or is it appropriate to ask you for an opinion? Looking at 180 with numerous or some multiple of glitch bills that'll be addressed, any major changes that you think will be removed or changed?
I don't know yet. I've just heard from various sources that some of the legislators are concerned about the overbroad nature of what's being captured, and that there's been some receptiveness to looking at narrowing the scope. But I have not heard yet where that might land.
So let me ask a question. Let's say there's unoccupied land in Bonita Springs, and we wish to increase, to designate that as a wetlands area. Are we not able to do this under 250 or 180? In other words, increase the amount of acreage in Bonita Springs for wetlands?
So wetlands is probably not a good parallel, because we're also already restricted when jurisdiction is controlled by the state or other entities on certain things. But if we were to say that we wanted to do a change in some of the areas that are already some of our lowest density, vacant areas, and restrict them, and even further, either change a definition that said that certain things that, let's say we're to come up with our own wetland definition, and that definition is more broad than a state or federal definition. If that had the effect of restricting development, of turning dirt, then that would be a prohibition.
Reality is they kind of have us, the state legislature. I mean, from our perspective, it sucks. They've really taken our autonomy. They kind of get a win by saying they've made the state more efficient, but our ability to manage our affairs how we are used to doing it is pretty much gone. The people who come on a regular basis, and every time there's a development issue, and have, binders this big and all the reasons why they're gonna no longer be mad at us, because we don't have the ability to even stop it if we want to. So and the thing is, we can't get cute. This will be kind of one of those FAFO situations. If we mess around, we will find out. They're hoping municipalities will test them, and then when they do, they'll be like, okay, I smite you. And that's not where we want to be. So we just kind of got to take it at the moment. Sometimes you're like struggling, you're trying to get away, and you're just like, you just got to relax. There's nothing, fighting is going to make it worse at this juncture.
I sort of agree, like with a riptide.
Go with it forever.
If not, you go under.
It's not forever, and maybe there is a way to legislatively address it, but you're going to have to ask the legislators to undo that and give the power back to us. What are the chances of that happening?
Well,
I would say zero.
I think they might have bitten off a little too much, because they're also limiting our extension of emergency status, and that they want to, after 1 month, the county commissioners will approve anything we want to do, whereas when we had our extension of emergency service, we could do it ourselves and then hand in. And if we get hit by a major storm, they're just going to be hit with, when are you answering? When are you answering? When are you, you can't micromanage. And that's what I see the county commissioners, and even worse, the state legislation trying to do.
It's really all the state. It's all the state legislature. I don't want to specific legislators. I'd just say, in general, the state legislature wants to control us, and the two mechanisms to do that are going to be making rules that both the county and the cities have to go by. And if you don't go by them, then you're not listening to the state, and then you will be listening to no one else.
So the basic rule right now is that the council cannot function as a legislative body to make changes to the comprehensive plan or to the land use code. We can enforce what we have on the books now. But we're precluded from making policy amendments or policy changes.
So, yes, that's the short answer on it. The first bill Senate Bill 250, I think the intent of that was as a result of, especially because that was sponsored here by Senator Martin. The goal there, I think, was there were a lot of people who were trying to rebuild after the storm, and that was the first time they were hearing about the 50% rule and those issues, and they never really dealt with them. And of course, Lee County being a far larger jurisdiction than some of the other jurisdictions that have been hit by storms in recent years, I think that there was an attempt to just, prevent local governments from moving into the breach and trying to restrict development on coastal areas or to make things over restrictive. And that, the little lead in at the beginning of with Helene and Milton at the beginning of Senate Bill 180 in Section 28 is to say, oh, we're doing that statewide, even though statewide that has not really been a large effect. And so the idea is, well, it's only a temporary restriction. Now, I think what the legislature is also trying to do is they're trying to do is what they've continuously tried to do with Live Local in other areas, which is they see the pendulum in the state where there's a lot more pressure to slow down development, but there's also a lot of demand, and they're trying to say, okay, well, if we freeze things and we say you can only essentially over entitle property, we're going to encourage more building and more demand. We're going to increase the supply issue. So I think they're working on a little bit of the supply side as well. Now, when I've talked to other city attorneys and some of the attorneys that are thinking about bringing challenges to this, the issues that David brought up about, challenging the constitutionality of one element, of course. There's the other side of it is the legislature is also giving us direction through the coastal planning elements and other elements to say, well, we want you to restrict things. We want you to, it's not just the FEMA rules, but the Florida Building Code also requires that there's a 50% rule to make sure that, someone doesn't keep an old, 1930s electrical wiring in it forever. They're trying to catch things, to bring things up, because that all helps in post-disaster issues, resiliency, et cetera. So I think there's probably, those are going to be the issues that get addressed in any glitch bills, which is say, like, well, some of the other policies you're telling us to do, we can't do as a result. I think that until 2027, planning is fine. You may even be able to implement some new restrictions if they're voluntary in nature. For instance, I've heard discussions mentioned about transferable development rights. So if you just say, okay, we identify an area where we want to restrict development, you say, well, we'll let you build there. If you really want to build there, you can build there. You're probably not, there may be other reasons why you might not want to build there. There may not be adequate emergency services. There may not be power, utilities. There may be a lot of reasons that making that site unattractive. And you may be able to say, take an existing policy like our infill policy and say, we'll let you transfer your development rights from this large acreage property to an infill property, and we'll give you bonus density on top of it. So there may be other policies that that have the effect of restricting density, but are private, that encourage private initiated development to have that occur. But that's sort of the lay of the land as I see it, right now in 2025.
So if we as a council wanted to adopt policy that would promote ADUs or to promote the development of workforce housing by private developers, are we precluded from doing that?
There's no restrictions on that.
No restrictions on that, okay. Just trying to figure out what the rules are.
I don't really see anything that we want to restrict, so I don't think this is really affecting us at all, so. At least in my opinion.
It's the principle. But yes, I agree with you. It's not like we're trying to restrict certain things, but I mean, the ability that we don't have the autonomy, I think is probably what people tend to have the exception to. But we have to get used to this, because this larger discussion that they're having on property taxes and how that ends up shaking out is going to be, there's going to be direct correlations to how we look at budgets too, and what is that going to look like? And is it going to be homestead properties? Is it going to be, is it just going to be something that takes place over time? Is this going to include a sales tax that's going to have to also increase? Is that going to be up to the state? Is that going to be a municipality thing? The legislators, that's doing this is kind of like, hey, I'm trying to make the state more efficient, but they're also gonna be like, hey, look, I'm gonna help them make the decision easier that they can't raise taxes. You guys know me, every time we go up for budget, I'm like, I think we should do a rollback, and then it doesn't happen. But, point being, they shouldn't be able to restrict my ability, or your ability, or anybody else's ability to raise or lower. And that's unfortunately, I think we're gonna be headed in a way where that will not be off the table too. So it's like, you really have to just kind of look at these and just understand them for what they are and try not to overreact, over-struggle, and kind of like see where this is going to go, because change is coming in both the land side and I think how we're doing property tax is probably going to change too.
However,
Yeah, open up might work maybe.
if we get rid of property tax, there will be a new tax. It's already been told to me by several county commissioners. Oh, we'll just like redefine where we're gonna tax. They will get their money.
There's going to be huge issues because the reality was the property tax thing. It sounds great to say let's get rid of property taxes. However, West Palm, Lee County, Collier County probably be fine, but the middle of the state and northern state that doesn't get any.
There'll be a new tax.
Absolutely smush. And to make it work, you have to raise the sales tax. But even that isn't necessarily a good solution for 70% of Floridians who don't live on the coast in nice areas. So it's there, and so yes, everybody hates taxes, but guess what? We all like roads, we all like schools, we all like police, we all like fire. Those services are all derived from property taxes. So yes, I want to get rid of property tax, but the conversation should be, how do we replace this income, and then what are we going to do? Not let's
Because
get rid of
if
it.
it's sales tax, Ian cost us $1 billion.
Sales
So
tax would almost
we
have to be at 13.
would have been paying no sales
You're
tax.
almost gonna have to double. You're gonna be at 13 probably, is what some people are saying, which is not something that people. We're at 6. The idea of that, horrible. What does that do to tourism and all the other stuff? So I'm not saying, this isn't me saying we put property taxes or being biased because our budget is derived from it, but understanding the money. It's a easy thing to say to people in general. Let's get rid of it, but the devil is always in the details of that.
Cure is going to be worse than the disease.
Sometimes, and that's this rally of let's get rid of property taxes. Every time I hear it, I'm like, okay, but what's this? How are we gonna take? Where's the rest of the money coming from?
So can I, while David is here and Zoom is working, I wonder if it's helpful, David, I don't know if it's helpful or if you have some feedback on when the state's saying more restrictive or burdensome, how is that being defined? How is more restrictive being defined? How is burdensome being defined? Or do we not know that yet? 'Cause I hear-
There's nothing out there, Dr. Banyan, that provides us with a statutory definition. I would look at it legally. If it's more burdensome or it's more restrictive from a development perspective, if you lower density or if you make it more difficult to develop, then it's more burdensome or it's more restrictive. But there's no case law yet as it pertains to Section 28. There may be some case law just generally about those two words, but there's nothing yet, and the statute did not provide any definitions.
We can make it less restrictive. We can increase things like height and density, but we can do nothing backwards in the other direction, essentially.
Derek, does this have any impact on us when we have plans that go through zoning and come to council where variances are granted? Should we be a little more cautious about variances? Is that gonna come back to bite us?
So there are in both Senate Bill, I'll flip the statute, but there are provisions, I want to say it's in this one too. In Senate Bill 250, it says you cannot enforce existing regulations that have the effect of doing things. So is it possible someone could say, well, I've asked for a variance under your existing regulations, and you enforcing those the letter of the law, those regulations could be in violation? I think people can make the claim. I wouldn't be overly concerned about this.
When would a variance be more restrictive?
Well, no, denying one.
Right, okay.
I would add to that, though, that the variance would be based upon criteria that's already in your code. So it's not a new regulation or a new ordinance. You're implementing what you've already adopted. So I think you're going to be okay there.
Yeah, the biggest concern would be, in the language of Senate Bill 6, is adopting more restrictive procedures. So this is the procedures is one of the question marks that everyone's had, which is, well, what happens if we change our application criteria? And the application criteria has a new, we want an extra submittal, something that's not in the code. So I think new interpretations, new policies that aren't written down, that weren't previously adopted, those would be all the concern areas going forward.
Yeah, I would add, Derek, that, there is a safe harbor. I know some local governments are looking at it, well, we'll adopt it. And if somebody sends us the letter saying that it's more burdensome and it's more restrictive, we have the ability within 15 days to repeal. If nobody does, we're good to go.
Yeah, so I was actually been looking at the resolution we're adopting with respect to look back. I've been questioning whether or not I'll build a vested rights provision in somewhere else and do something like that. And so I'll continue to look at that issue and see if maybe we want to create a process. But from the perspective of repeal, I've seen this issue brought up a couple times by local governments looking to repeal. So the language of statute said they're void ab initio, so there's nothing to repeal. So I haven't really jumped down that rabbit hole. So these are to Councilman Burton's point, these are attempts by the legislature, obviously written by committee, probably last minute, to try to fix more global issues than the issues that they're purporting to address. And as a result, they're poorly written. And as a result of being poorly written, they don't fit into the legal framework and regime of other planning requirements that the legislature has required, or FEMA, or other programs that we work with, and they can be internally inconsistent with themselves. So I think we'll deal with these issues on a first come, first serve. I don't think that we're actually going to be dealing with a lot of this, except for because the city of Bonita Springs we're in our final stages. We're approaching build out. You've got policies in place for your core areas that you're working on trying to redevelop, and you're spending money to redevelop. I don't think that we're likely to see a lot of issues with that. We're more likely to see difficulties implementing the Live Local Act or some of the other legislative mandates that have been placed on you. And to the concerns that what I would say is when you're talking with the lobbyists, and you're talking with the legislature, I think we'll focus on highlighting all the good things that the city is doing, so that we can. I can guarantee, and I'm sure David and Margaret have plenty of experience in too, every time there's a bill that comes down that restricts local government or tells them that they're preempted in a particular area, you can usually track that back to some city who overreached and did something that burned everybody else. And rarely does the legislature say, well, here are cities that are doing good things, and we should implement programs that mirror those. Instead, they just say, you're not going to deal with this. And so far, that hasn't created a lot of problems, but as they talk about things like getting rid of property taxes without figuring out how they're going to deal with that, it's not the same as saying we can't regulate vacation rentals. Someone's going to have to pay for those services, and so I think it's a little more difficult the next big bite they're looking to take down.
A good example was that, remember the wet foot, dry foot thing a couple of years ago in regards to the beach and stuff, and there was 2 counties that kept jerking around, so they're like, okay, guess what? Everybody has a new rule. So that's kind of how it works with them sometimes. I would say one thing that I was thinking of while you were just talking about, is this in any way inhibit the furtherance of our discussions earlier collectively about merging potentially LPA and zoning? Because I think that would actually expedite the process, not slow it down. But what are your thoughts on that?
I think it's one of those issues. It's going to meet the spirit of the law. The letter of the law will be in the details of how we implement it. So, I have actually seen a couple of jurisdictions that had merged theirs and then had to repeal them and go back to two again as a result of Senate Bill 180. Because, you know, it's not true that every jurisdiction is out there restricting things. A lot of them are trying to streamline things as well. So it's going to depend more in the criteria we use for the boards rather than the makeup of the boards themselves. So I think what we've talked about at the city council level is that by combining the boards, we're going to add a little more expertise, and from the members of the boards that have been involved, often they're asking what happened to that project that we worked on previously. I think, you know, I think that's not going to be a problem. We're going to shorten the review period. We're going to shorten the process. So I think that's not a problem. The issue will be when we adopt the standards for the adoption of comp plan amendments or rezonings, variances, special exceptions. It's those criteria that are going to be this. We just port the same criteria over, it's not a problem. But we were looking to actually change them to make them more, to make more sense. That doesn't mean that they're going to be more restrictive. So I think that's still an issue that we can keep working on.
I agree.
And if I-
And what
Go ahead.
about how the county commissioners run their zoning?
So the county commission does, they have a hearing examiner's office.
Yeah.
So they, and City of Cape Coral has one as well. So they run everything through the hearing examiner. And there can be, you have to participate in that process to then go in front of the county commission. If we were to adopt those processes identically, even though I think that you'll find that for the most part, developers they feel more consistent when they deal with the hearing examiner, I would still say that that process is more restrictive because it does have, it's designed to protect the county from decisions. So what it typically used to happen is the county would have a hearing examiner, essentially an expert who would review things. It'd be a contentious process. And then it would go to the commission, and there would not be a very lengthy evidentiary hearing. It would just be, we don't like this, throw it out. And so they've restricted the ability to participate at the county commission level. And so that
Because it's still
restriction would be a restriction.
quasi-judicial.
Yes.
You can still ignore whatever like maybe a combination or maybe more scrutiny on the folks that we put on the board.
I mean, I think if you want us to look at a hearing examiner process, I think that's not a bad idea. We might want to consider how much that costs.
I was going to say, what does that cost?
Is
Because
this
it seems,
fruitful before we know what's going on with 180?
Well, to the degree that all these conversations are good for thinking about what's going to happen on November of 2027, assuming 180 doesn't get extended, you know, that's all stuff that we can work on. So we're not just twiddling our thumbs.
I know that David had something. David, did you?
Thank you. I was going to give you a real world example of the impact of Section 28. We represent a property owner in Orange County, and the county commission processed a plan amendment that removed some development entitlements to the property owner. And so we have sent the letter to the county commission informing them that we believe their two ordinances are more restrictive and more burdensome. The county commission held a hearing to determine whether they were going to repeal those ordinances. They decided not to repeal. And so we have filed, if you recall, the statute allows a civil action. We have filed a complaint for declaratory judgment and injunctive relief. We have also filed a motion for preliminary injunction. The statute states that the court should enter a preliminary injunction enjoining enforcement of the ordinances. And then we have also, in our complaint, requested an award of attorney's fees that the statute allows. So it's in real life, it's happening.
Let us know how it works out.
Thank you, David. That's helpful.
Thank you. And Margaret, I haven't had a chance to catch up with you and Arlene today. I did hear back from Department of Commerce, and they're trying to set up a conference call on Friday to go over their comment letter, I think from 2024. And because for the city council's benefit, there are some instructions that the department had provided to the city in 2024. And we wanted to chat with the department about, if we follow what you put in your letter, are we inadvertently triggering a Senate Bill 180 issue? So we have scheduled an appointment with the department for Friday to have that discussion.
And that will provide a lot of clarity, I think, for what our work upcoming.
Yeah, they called back today.
What's a preference of council? Do you want to take a short break, or do you want to, we have a section with David talking about some of the implementation decisions.
I think there's been a request for a break, so.
Has there?
Yep.
So,
10 minutes.
10 minutes? Okay.
All right.
Thank you.
Thank you.
That was my plan.
Smaller than the bigger containers. You don't want gum?
Hey, Mike, are you feeling okay? You feel a little lightheaded right now?
Listen, they're not.